Ohio, the Honorable Senator Fox presiding, is now in session. Please be seated.
Good morning, everybody, and welcome to the First District Court of Appeals. We have 3 cases to be argued this morning. When I say the case name, if you could please, the attorneys could please rise, identify yourselves, and your readiness to proceed. The first case is State v. Hale.
William Norman for the appellant David Hale, ready to proceed.
Good morning, Your Honor. John Hill on behalf of the state, ready to proceed.
Okay, thank you. Our second case is Frederick C. Weckel v. Cole and Russell Architects, Inc.
Good morning, Your Honor. David Tochia here on behalf of the plaintiff appellate, ready to proceed.
Good morning, Casey Bond on behalf of appellant defendant Cole and Russell, ready to proceed.
Okay, thank you. And then after those 2 cases, we will take a brief recess. When the panel comes back, the case will be State v. Collins.
Stephanie Lake on behalf of Ms. Collins.
Thank you.
Good morning, Judge Keith Sauter for the state.
Okay, thank you.
Thanks.
Okay, Mr. Norman, when you are ready, you may come up. Would you like to reserve any time?
Yes, Your Honor. Please reserve 6 minutes for rebuttal.
Whenever you're ready.
Distinguished panel, opposing colleagues, observers in the court. My name is Attorney William Norman. I represent the appellant David Hale in this matter on direct appeal. Your Honor, this case essentially involved an investigation that relied on eyewitness testimony. However, at trial, the government did not present any eyewitness testimony from the alleged accuser, which caused them to try a myriad of other attempts to try and get evidence before the court, all of which were impermissible. I want to talk about 3 of those issues today, although there are a myriad of them identified in our briefs. The first is the DNA issue. While my colleagues seemingly relied on the ambiguity left open in Williams, the Supreme Court of the United States has recently clarified in Arizona v. Smith that you cannot have a DNA expert testify as to information done by other technicians or other experts. They have to be there to present that testimony.
Now, the trial court did not have the advantage of that case. Is that correct?
That is correct.
So should we remand it for the trial court to be able to take that into consideration?
Your Honor, I think that you can go straight to the effect here and order the new trial. The reason why is twofold. Number one, when a case becomes decided on appeal, it is as though that has been the ruling. It's particularly when you have a Williams type of ambiguity. This is not law that was settled the opposite way and became unsettled by Smith v. Arizona. Rather, there was a question left unanswered in Williams, and the government relied on that ambiguity or that unanswered, unresolved question. But when Smith v. Arizona comes in, it completely settles the question. I don't know if the state really even has any other argument, because clearly this was unlawfully put in because they relied on underlying experts. And the idea, I guess the only thing left they would have would be harmless error, but the idea of DNA being harmless error in a rape case is I think, just kind of a non-starter. So there's the DNA issue, and we think that that's standing on its own and separate and apart from anything else requires a new trial.
If we were to agree with you, would all of the other assignments of error other than the sufficiency be moot?
In so much as the case would be remanded, I suppose the government may still have some arguments on appeal, and so the court may want to resolve the issues, all of them, so that they could all go up if my colleagues decided to bring it up a level. So, I mean, in effect, yes, a new trial, aside from the sufficiency argument, is the result of all of our errors. So in a sense, it could be moot. However, I think that you could take the opportunity to analyze it, given the fact that this may go up another level, at least possibly.
So your concern is the reoccurrence of the error, is that what you're saying?
Certainly, that is true, and I also think that it's just very clear, right? So the idea would be, well, we're going to send it back to the court to see if it's harmless error. I mean, the harmless error analysis is right before you. We know what those exhibits were. The courts of appeal do this all the time, where they decide, okay, this evidence was not permitted in. We're going to order a new trial because we know it was not harmless. Courts of appeals do the harmless error analysis all the time, so I don't think that you need to remand it for further proceedings, I think.
So I think I heard you say that when it comes to DNA evidence, it could never be harmless. Is that what I just heard you say?
I suppose there may be some sort of hypothetical we could dream up in the way of law school or something, but the idea that, especially in a case like this with no eyewitness testimony, the DNA evidence that was referenced in the closing argument and seems to be the only physical evidence that the government even puts forward, I can't think that would be harmless. So maybe not never, but just certainly not in the main gravamen of cases. So the last thing I think I want to talk about before we get into my rebuttal is the J.C. House interview. So essentially what the government has to do is they say, look, we concede that all of this evidence came in improperly, but we think that the J.C. House interview came in properly, and it is so overwhelming that it stands to make everything else harmless. We submit that it is not only unlawfully admitted, but also wouldn't serve to make everything else harmless. Let me briefly explain. Number one, J.C. House interview, the government claims it came in as a medical records exception. It was not brought in a medical record exception. If you look at the questioning around the time they showed the interview for J.C. House, they're talking about, hey, does this refresh your recollection? Which is exactly what they tried to do with the other interview.
So remind me, when they first played the J.C. House, that was during the juvenile's testimony?
Yes.
Okay. And then the interview with the detective had already been played.
Yes.
And now, and then I know you're saying that she didn't testify, but she did say that everything was true in the video. She did say that.
I have looked for case law to find where a witness can simply point to an external statement that was not sworn under oath, was not subject to cross-examination, and just say, hey, yeah, all that's true, and somehow that comes in place of testimony. The proper procedure for a recollection refreshed is that they would play that video outside of the hearing of the jury, and then the testimony is the evidence, not the video that was shown. And so, no, I do not think that by adoption or something, somehow all the words of that interview are now gospel record of this court. I think that if my colleagues wanted to make that a record, they could have said, hey, you heard your statement, will you testify to this now? Well, clearly she wouldn't do it.
So she adopts this interview with the detective, and then remind me then how the JC interview came into play.
Because again, she will not say that these things happened. And so in lieu of that, they try every single thing to try to get her past statements in. I think they didn't really have much of an idea of why it was coming in.
But would you agree, though, that that interview could have been introduced, right? It's these types of interviews are often introduced in cases like this as medical statements for
Number
medical.
one, J.C. House is not established as any kind of a medical treatment center or anything.
You're arguing foundation then of how
At least foundation, Your Honor. Also, they don't say it's a medical record in the trial. They talk about refreshing your recollection. Hey, does that refresh your recollection? They don't say, hey, were these questions made for the purposes of diagnosis? And if they wanted to enter it in as a medical record, they could have bought the J.C. House interviewer, because that would be the person that would need to lay that foundation, certainly not the juvenile. And so, Your Honor, we don't think that it's properly admitted. First of all, because it wasn't even entered as a medical record exception, and if it was coming as a recollection refresh, it wouldn't be played in front of the jury nor sent back under Booley.
So let me ask you this. If the record is clear that it was being used to refresh recollection, and let's say that arguably it could have been a medical record, arguably, okay, and you just finished talking about foundation, could it be said that the state waived that?
I certainly think so, because their argument in the trial court, such as it was, seemed to be about recollection refreshed. The very basic foundational questions that you asked is, were these questions asked for the purposes of making a medical diagnosis? That's something you ask in any 8034 exception. They didn't do that because they didn't even have the interviewer. They tried to bring it in through the juvenile, but that's just, now you're just using a prior inconsistent statement or a prior recollection refreshed. They tried to get this in. Maybe it could have come in medical if we found out that J.C. House was medical and if these questions were made for that purpose. But we don't have any of that in the record. We have it new on appeal that, okay, now it's a medical record. But if you look at that, they just don't have the goods for that. So it doesn't come in, and even if it were, if you look at the exhibits that were admitted, there's no way those could be harmless error just on the basis of the J.C. House interview. The J.C. House interview itself should have been redacted. My colleague concedes that. So then you have a piece of evidence that should have been redacted, but because it was put in unredacted, it's going to take everything else out and make it harmless error. I mean, the other exhibits contained inflammatory, highly prejudicial other acts evidence that were outside of the time of the indictment.
Mr. Norman, if you would like to reserve, you have 5.5 minutes.
Yes, thank you. So we'll see what comes up on the other side, but I think for those three reasons, it's very clear that if this court doesn't find insufficiency, that these things are more than enough to bring a new trial. Thank you.
Good morning, Your Honors.
Good morning.
I think that Mr. Norman and I agree on a couple things here, and that's what's important in this case, that being the lab reports, the DNA issue, and then the admissibility of the J.C. House issue. So with the court's permission, I want to start with the Smith versus Arizona issue. First of all, I would note, as Justice Zayas pointed out, that Smith was not the law of the land at the time that this was decided. This would have been examined under a Williams framework, which dealt with the raw data. But I also think that there's a fundamental misunderstanding of the facts in evidence here. First at the trial court level and now on appeal from the defense side here, which was basically that there was not a surrogate analyst. The analysts that testify, Catherine Daly and Logan Shepler, were the ones that actually did the analysis of the DNA evidence, and they described...
Okay, so it's my understanding that, yes, they looked at the numbers, they looked at the raw data,
right,
and they interpreted what it meant.
Right.
But they did not actually do the testing where they took the material, the DNA material or the sample, and I did whatever scientific process it was to take that sample and produce that raw data, correct?
And they described the process kind of briefly during their testimony. I know Catherine Daly did, and I think actually Logan Shepler got into it a little bit more. Basically this 4-step process of extraction, which is simply just removing the DNA from the item, quantification, which is determining what, if any, DNA is in the sample, amplification, making copies of the DNA, and then the electrophoresis, which is separating out the DNA so it's in sort of an observable, format or whatever. My understanding, from doing Innocence Project and some of this stuff way back when, is that it's basically all done through a machine. You've got different analysts that know how to work these machines, and it essentially spits out raw data that someone like Ms. Daly or Mr. Shepler would then take a look at to determine whether or not, there's a match or anything.
So if they didn't do the actual testing of the data, right? They did the analysis, but they didn't do the lab testing.
Right.
Right? What does Smith say about that?
Well, Smith deals with basically what's called basis evidence, and I'll invoke Justice Kagan's language here, basically using one analyst as a mouthpiece for another. I think this is distinguishable factually from what happened in Smith versus Arizona, because what you've got in Smith versus Arizona is you've got one analyst that did basically what Ms. Daly or Mr. Shepler did, and then they were no longer working at the crime lab, and so they come in with someone who had absolutely no involvement whatsoever, no personal knowledge of what procedures were used, didn't actually do the analysis. It would be like me going into court and testifying as to what Catherine Daly or Logan Shepler did, and that their conclusions are sound. It's a totally different scenario from the state's perspective.
But if for example, hypothetically, If a lab technician who was doing the extraction and, doing the actual testing,
Right.
if, for example, there was a possibility that there was some contamination, wouldn't the defense have the right to cross-examine that person?
Well, so here there were no representations from Ms. Daly or Mr. Shepler that there was no cross-examination. That would have been perfectly ample ground for, Mr. Kathman, who was Mr. Hale's defense attorney at the trial court level, to say, well, you had no idea if the procedures were followed, and they would have had to have candidly answered yes, but they never got into that. There was no representation to that effect.
Well, it was my understanding from reading the transcript that that Mr. Kathman was surprised that Ms. Daly and Mr. Shepler weren't the ones that did the testing.
I think there was probably a miscommunication. I mean, you've got States Exhibits 19 through 21, which have that exchange before and prior to this argument on the record between Ms. Brew and Mr. Kathman. I mean, there was a misunderstanding about who was coming in for what, maybe he was surprised, maybe he wasn't.
And he said he was.
Well, you could interpret that in a number of ways here, but basically at bottom here, I don't think that Smith, in light of the ambiguity of how it applies to something where we're dealing more with raw data, which is not necessarily a testimonial out-of-court statement, that's kind of the crux of this analysis, right? We're talking about...
That is a crux.
Right.
I mean, is that testing testimonial?
No, it's raw. I mean, if you look at something like Schmerber, which I know it's a different context, but they say that a blood test isn't testimonial, for instance. It's the nature of the thing. It's not a representation as to the ultimate issue, which is...
Do we have to look at why the DNA was tested in the first place in order to determine if it was testimonial? I mean, in this case, it was tested specifically for the purpose of a criminal prosecution.
Correct, but I'm not sure that that's necessarily what the analysis hinges on, is because what we're talking about here is raw data. It basically is just showing the nature of the thing. It's not testimonial for any particular purpose, i.e. on the ultimate issue, is it a match? That's kind of what my take on this whole thing is.
Well, they would have had, Ms. Daly and Mr. Shepler would have had to base their opinions on somebody else's reports or somebody else's notes or somebody else's comments.
I mean, I think the only potential question aside from the fact was there cross-contamination, were procedures followed, we're talking about, what is the source of this DNA, and there was, ample testimony relative to chain of custody. I believe Mr. Kathman, notwithstanding his surprise, was willing to stipulate the chain of custody exactly.
Well, that was just for chain of custody purposes. That wasn't for anything else. That was only chain of custody.
It does get to the ultimate issue, for instance, that, this sample came from here, this sample came from there. And if you look at Williams, that was one of the things that they talked about and then in Smith, in terms of basis evidence, was that you've got basically an outside lab that's representing, well, this was the source of the sample.
Well, you didn't really argue that in your brief, though.
I did. It's something that came to mind while I was reading Smith and Williams last night, Judge.
Okay.
So, unless there are any more questions on that particular issue, I do want to touch briefly on the J.C. House interview. So, actually, another thing that I noticed when going through the record last night, how the J.C. House got brought up initially, it was actually Mr. Kathman who brought it up during his cross-examination of C.H.
Let me ask you, and I hate to throw you off course here a little bit.
Sure.
Should we be asking for briefing with regard to Smith v. Arizona? And if so, what would you be asking for briefing?
Judge, if you want to ask for additional briefing on the Smith versus Arizona issue, I am more than happy to indulge you on that.
And what do you think we should be requesting?
What issue to examine?
Because you brought up a different issue.
I believe probably whether or not what I'm characterizing as raw data is testimonial for purposes of the analysis under Smith versus Arizona.
So basically whether Smith, Arizona applies to this case, is that?
Yes, yeah, that's the ultimate question, right? But notwithstanding, so getting back to the J.C. House issue, that was actually first brought up by Mr. Kathman. He made a number of questions to C.H. relative to what she told Ashley Bailey at J.C. House. That was the first mention of the J.C. House interview. At that point, I would say he kicked open the door to bringing that testimony in anyway, but notwithstanding that, he failed to raise any foundational objection to the admission of that, or really any of this stuff, whether it was...
So just hold on a second, just so I understand. His questioning about the J.C. House interview during cross-examination of the child.
Yes.
Opened the door to playing the entire J.C. House video?
I believe so, because he was asking her what she told Ashley Bailey. That would be our position on that. But notwithstanding the argument that I also made relative to the 803.4 exception, which also I think would have been applicable to the same nurse, he failed to raise any foundational objection to the admission of that. He's waived all but plain error, and I don't think you can find plain error relative to the admissibility of the J.C. House interview when this court has routinely acknowledged that that's, it's widely understood to be admissible for an 803.4 purpose. State versus Arnold would be the Supreme Court case. There was State versus Warner, which was a recent case, which I believe you wrote, Judge Krause. And then certainly from the surrounding circumstances, she'd just come from the hospital. She was describing recent conduct. I know there was some hearsay stuff about other acts, and I can get into that briefly too if the court has any questions about that. But from the surrounding circumstances, I think you could infer that it was for a medical purpose.
So one of the assignments of error is cumulative error.
Yes.
And what I see from the state brief is conceding multiple times that evidence was admitted that shouldn't have come in, that improperly admitted, including the sane nurse vouching. So what do we do with that? I mean, I understand in analyzing everything individually, but what do we do with all of these concessions of error?
Well, so this case to me reminded me of State versus Mincy, which was one of my cases when I was still a defense attorney. I believe you wrote the opinion, Judge Krause. That was a case where there was a lot of error, but the court nonetheless acknowledged that it was, ultimately harmless or not plain error. You have to look at things in the greater context of the trial. So the way that I look at this is you've got, I know there's a disagreement over whether the J.C. House was admissible for substantive purposes, the Detective Wilson interview, things like that. But if the court ultimately finds that the DNA was admissible, that Smith is inapplicable, and then that the substantive information about the abuse that C.H. suffered came in properly through J.C. House or some other means, I think the state wins, Judge. I think you've got overwhelming evidence, given that there was no objection to any of this stuff, whether that was inadvertence, whether it was kind of a kitchen sink trial strategy.
This would hinge on the DNA being properly admitted and the J.C. interview being properly admitted.
And I believe that's probably why Mr. Norman and I have spent the majority of this morning talking about it. So,
one last question on the DNA. I noticed that you didn't really make a harmless error argument in your brief on the DNA, because you're just focusing on the fact that it was admissible properly. But if we were to disagree with you,
I guess that
would it be harmless?
Mr. Norman and I agree on three things, because I don't believe that's harmless, at least not in the context of this case. I mean, it's a 1 in a million match on CH's breast and a 1 in 76 match inside of her labia. There was really no explanation for, how that happened, aside from some stuff about touch DNA and things of that nature. So that's sort of where the battlefield is in this
case. So you would agree that if it improperly came in, it wouldn't be harmless?
Absolutely not harmless. No.
Okay, all right. So, thank you.
With that, I cede the floor, I guess.
Thank you.
Thank you, Judge.
All right, thank you. Mr. Norman, you have 5 minutes and 14 seconds left. I didn't mention earlier, when I hit the yellow, that means you have a minute, and the red means your time has expired.
Thank you, Your Honor. Your Honor, quickly on the DNA, my colleague brings up the exact question that's posed in Smith v. Arizona, and that is it good enough to stand in with the cross-examination and say, listen, Mr. Expert, you didn't do this underlying work. You can't tell me it's airtight. And the Supreme Court said, no, that's not enough. That doesn't stand in place of hearsay and confrontation clause. And so I think that this is exactly the scenario that was brought up in Smith. That literally is the analysis. Is that if there's an underlying someone who had to do something technical to arrive at some underlying data set upon which another expert opines, that's a Smith violation. So I guess now back to J.C. House. Again, I just reiterate, when he says there's no plain error, I assume he must mean that the error itself is not plain, because he's saying this is really the only evidence. And so because it's the only evidence, he can't be saying it's harmless or, that there's no miscarriage of justice if someone's convicted on inappropriately admitted evidence. So he must be saying, well, you might be able to find hidden in the inference a medical record exception here. And so I will concentrate the rest of my time on that. Your Honor, in order to make a medical record exception, you have to bring in a medical record custodian. That custodian needs to testify as to the authenticity, and they need to be able to answer certain questions about the purposes of the questions. If the purposes of the questions are for some medical diagnosis, a medical record exception may be found. Even in that case, the evidence is subject to redaction, is also subject to 403. So now take this back. We go to the J.C. House interview. You will find nothing in the record setting a foundation for medical records exception, absolutely nothing, except for speculation from my colleague here. He's doing his best with a very difficult record. You will find, in fact, they attempted to bring it into the recollection refreshed. As I stated, you can look at the record for that. Because you don't have a medical record exception foundation laid, you didn't even bring in the witness that you would have needed to even attempt at that. It's clear that this was improperly introduced.
What about the opening the door argument?
I would love to see some case law that says because I mentioned an interview, it gives you the right to play it in. And I don't even know what rule of evidence would he claim then? Would he say it's a prior inconsistent statement or something? But then do that procedure, right? And so that wasn't done here. So in the counterfactual, could it have come in some way, somehow, if it had gone very differently, perhaps? But I think that the idea of opening the door here, this wasn't subject to a motion in limine. This is not admissible evidence in its current form, unless it's testified to and established through the medical records exception, in which case it would have to be offered in a limited way and we think redacted. Lastly, with regard to the DNA evidence, I just want to say one last thing, that he's saying it's not harmless error, so I guess I would just point back there and say, really, I don't think that you could look at the J.C. House interview, even if you found that it was substantially lawfully introduced, even if you found the medical record exception. I don't think you could look at that one unsworn statement, not subject to cross-examination, and importantly, something that they would not testify to at trial, and say that overwhelms all of the improperly and even conceitedly improperly introduced evidence, particularly when it has major inflammatory and prejudicial statements throughout. Your Honor, this case is riddled with evidentiary problems. We didn't even get into, I think that one of the judges brought it up, the vouching. It's riddled with problems. The cumulative error is also available to you. Pick a lane. This case needs to be reversed in a new trial ordered. Thank you.
Thank you. Your case has now been submitted, and an opinion will be issued in a timely manner. Thank you. Okay. And if I could have the next case, Weckel v. Culp and Russell. Ms. Bond, whenever you're ready, would you like to reserve time?
Yes, Your Honor. 3 minutes, please.
Whenever you are ready.
May it please the court, Casey Bond for defendant appellant, in this case, Cole and Russell Architects. This case has a very tortured procedural history. I want to focus on the res judicata issue today because that issue is dispositive in this case. The key issue is whether the current claim that is before the court arises from a common nucleus of operative facts as the claims in the prior litigation. Regardless of whether there are different legal theories that cast liability on an act, that does not in and of itself create multiple transactions. The initial claim in 2004 in this case focused exclusively on how Mr. Weckels' shares of stock in Cole & Russell were to be redeemed. That is the nucleus of operative facts here, the redemption of Mr. Weckels' shares. The initial complaint filed back in 2004 specifically sought declaratory judgment that Cole & Russell was obligated to repurchase those shares in a particular manner. In other words, it was an enforcement of a settlement agreement, but the substance of that settlement agreement was how those shares were to be redeemed. Mr. Weckels admits that the claim he filed in 2004
within that lawsuit, the shareholder agreement was not part of the lawsuit, as I understand it. It was simply the defunct settlement agreement.
That's correct. I mean, that's the issue. The shareholder agreement should have been identified as an alternative claim. At the time that the 2004 complaint was filed, Mr. Weckels acknowledges that the obligation to redeem his shares had been triggered under the shareholder agreement. His position is upon termination, that obligation was triggered. At the time, prior to when the initial complaint was filed, Cole & Russell had submitted a check as its first installment payment under the shareholder agreement. Mr. Weckels argues in his brief in this case that he could not accept that check because under the shareholder agreement, the amount of the check was incorrect because it was based on an incorrect evaluation date. Therefore, at the time that initial lawsuit was filed, there was a valid breach of contract claim that could have been brought under the shareholder agreement. And it should have been brought under the principle of res judicata as an alternative claim. He acknowledges the only two methods he had to redeem those shares were the settlement agreement, which he sought to enforce, and that if that was not enforced, his plan B always was and only was the shareholder agreement. So that breach of shareholder agreement should have been raised as an alternative claim in that 2004 complaint.
Could you explain to me how the claims would have been ripe in 2004, the breach of contract claims?
Yes, Your Honor. At the time, as we mentioned, Mr. Weckels acknowledges in his brief that the obligation for Cole & Russell to repurchase his shares began on the date of his termination.
I understand that.
Which was March of 2004.
Yes.
Pursuant to that, those obligations, Cole & Russell submitted a check.
Yes.
A payment.
So there was no breach.
There was a breach. Mr. Weckels says he could not accept that check because that check was it was not sufficient. It was the wrong amount. He says if I had accepted that check, if you'd multiplied those payments out over the 10 annual payments, I would have been $400,000 short of what you owed me under the shareholder agreement. In other words, there was an obligation, a duty. There was a breach because Cole & Russell, pursuant to Mr. Weckels' position, the payment that they submitted was insufficient. There was a duty and a breach. There were damages. That's a valid breach of contract claim at that point. And in fact, between the time the initial complaint was filed in September of 2004 and when the first amended complaint was filed in November of 2005, when Mr. Weckels abandoned his attempts to enforce that shareholder agreement, the only method of repurchasing his shares that existed when that amended complaint was filed was the shareholder agreement. At that point, it had been about 18 months since Mr. Weckels had been terminated. No payments, no proper payments had been made.
Had there been an appraisal report at that point? Isn't that what triggers payment?
Yeah, that is not in the record. There was what triggers payment under the shareholder agreement was that within 30 days of the termination, then you have to make it, and it's based on the valuation report would come into play when there's a fight over what's the proper valuation date, which Mr. Weckels has raised in this case. But the initial position, in fact, that's another reason why a claim for breach of contract of that shareholder agreement at the time of the initial lawsuit was the claim that Cole & Russell was giving weight to the wrong valuation date. By the time the first amended complaint was filed in late 2005, there had been 2 payments that would have been due. The first payment, which was made, was the incorrect amount, according to Mr. Weckels, which was a breach of the agreement, so he rejected it. He then, in 2005, made clear he was not going to accept another payment because he felt the company was in breach because of the valuation date it was assigning. So there was a even clearer breach of the shareholder agreement as Mr. Weckel would view the world at the time he filed his amended complaint in 2005. And he absolutely should have, and was required to under res judicata at that point, file that claim because, again, what we're looking at is how were his shares going to be redeemed. And that was the only method that remained at that point. I'm not going to spend time talking about the repudiation issue. I think it's really laid out pretty thoroughly in the briefs. I would like to touch on the prejudgment interest issue. Well, first let me talk about the motion for relief from judgment. There is, as I've talked about, one of the important facts here is what is the proper valuation date? Now this assumes that you find in favor of Mr. Weckel on the res judicata and that he can validly bring a breach of the shareholder agreement at this point. There is a factual dispute as to what is the proper valuation date. What the shareholder agreement says is if the termination is without cause, there's one valuation date. If it's a termination with cause, there's a different valuation date. The judge conflated the contractual provisions about with or without cause with the jury's determination in the underlying proceeding. The jury in the underlying case did not decide whether, under the terms of the shareholder agreement, Cole and Russell terminated Mr. Weckel with cause or without cause. Cole and Russell was simply defending itself against a claim that it violated Mr. Weckel's rights as a minority shareholder. And in order to defend against that claim, Cole and Russell had to demonstrate that there existed a legitimate business justification for its decision to terminate his employment. But that doesn't mean, just because there existed a legitimate business justification, that doesn't mean that contractually Cole and Russell relied on that reason under the shareholder agreement. They're 2 completely separate analyses. And because of that, it has never been determined what is the proper valuation date. There is evidence in the record that was cited to the trial court supporting that Cole and Russell, in fact, although it had a basis and it could have terminated him with cause under the shareholder agreement, it made the conscious decision to terminate him without cause because it was hopeful that they could amicably part ways and give him a soft landing. As we sit here 20 years later, we realize that didn't work out so well. But they're 2 separate issues, and it is improper for the judgment of the trial court is based on the jury's verdict in a minority shareholder wrongful termination claim, and that's the improper analysis. So if the court does not side with Cole and Russell on the res judicata issue, the judgment needs to be remanded for a proper evidentiary hearing as to what is that proper valuation date. And then on prejudgment interest, there's really 2 issues. There's what's the proper interest rate and when does that interest start to accrue? Mr. Weckel's position on the prejudgment interest really demonstrates why this case should have been barred by res judicata. Mr. Weckel argues that the interest rate from March of 2004 should be applicable as the prejudgment interest rates. So Mr. Weckel argues that his claims against CR Architects, or Cole and Russell, as it was known back then, didn't become ripe until March of 2018, and that prior to that, he was not able to pursue recovery under the shareholder agreement. At the same time, he claims that Cole and Russell was nevertheless required to make payments under the shareholder agreement beginning back in November of 2011, after he demanded payment under the shareholder agreement. A demand that, again, he says he could not seek to enforce because it wasn't ripe. Yet at the same time, he's also arguing that the applicable interest rate should nevertheless stem from 2004, which is when CR Architects' obligation to pay him under the shareholder agreement arose. Though that's his position. If Colin Russell's obligation to pay him arose back in 2004, these claims are barred by res judicata. If, as the trial court found, these claims were not ripe until 2018, there is no way, and under any type of equitable principle or legal principle, that you can say Colin Russell owes interest dating back to 2004. In fact, Colin Russell tried to pay Mr. Weckel back in 2004, and he rejected that payment. In our position, that means he repudiated the shareholder agreement. He never wanted to redeem his shares under the shareholder agreement. He wanted a more lucrative payout, which involved repurchase of the ESOP. All of that aside, if we get to the point of prejudgment interest, which we think we never should, it's certainly, you cannot apply interest until at 2018 at the earliest. In our position, 2021 is really when the judge first said there is an obligation to pay, and here's the valuation date. And until that evaluation date was determined, the actual amount owed would not have been known. I'll reserve the rest of my time for rebuttal. Thank you.
Okay, thank you. Whenever you're ready.
May it please the court. There's a lot in these briefs, a lot of technical issues going on, but I want to step back for a minute and look at the transaction here, because I think everything needs to be filtered through that lens. Back in 1994, Mr. Weckel paid over $150,000 for shares of Colin Russell stock. He paid that money pursuant to the shareholder agreement. And when he paid that money, his performance was complete. He didn't have to do anything else. He didn't owe Colin Russell any more money. He did his work. The value of the stock increased. The bargain was, I'm going to buy this stock. After my employment ends, Colin Russell will pay me whatever the value of the stock is based on the valuation date in the shareholder agreement. It's a very simple arrangement. Today, despite the fact that Mr. Weckel has paid for his shares, Colin Russell has paid him nothing.
Well, they attempted to, twice, correct?
They attempted to, and that's they attempted to, the first time was in September of 2004. 3 or 4 months before that, we had an agreement that Mr. Weckel could redeem his shares through the ESOP. That was an agreement. The parties agreed to that, and we're working through that agreement at the time they foisted this first payment on Mr. Weckel.
So one of the matters that your opponent is relying is a determination of fact with regard to why that initial check was not accepted.
Yeah.
So what is your position on their determination of fact on why that? Is that really supported by the record? Is that like?
Not really, Judge.
Because it's treated as outcome determinative by your opponent.
I understand,
Yeah.
but there's much more to it than that. The check was returned, and this is detailed in a very lengthy letter that I wrote to Paul Calico. It's in the record, detailing the history of what led up to that. The check was returned because there was an existing agreement, not for Mr. Weckel to get his shares through the shareholder agreement, which is what Colin Russell was demanding at that point in time, foisting on him. We had an agreement that he could sell his shares to the ESOP as part of the 2004 settlement, in addition to getting substantial severance pay and other benefits. The 2004 agreement wasn't just about how's Mr. Weckel going to redeem his shares. It was a complete separation agreement. It had severance pay, it had benefits. It was much larger than this isolated issue that the defendant wants to make.
As I understand it, it was intended to mirror a retirement. Am I understanding that? There was someone that had retired and there was a package that was offered, and so your client was seeking to have a similar package.
Yes. Tom Cole, one of the founding members, had retired. The 2004 settlement was based on the terms that he retired under, which was to sell his shares to the ESOP with loan guarantees and restrictions, and that's where everything fell apart in 2004.
So the check was not returned because the payment was wrongly valued?
No, Judge.
And because that's where their argument starts with when the
Correct.
claim could have arisen.
And if there was a mutual mistake
Right.
that we discovered long after that, before the 2005 agreement, before the 2005 case was filed. At the time the 2004 check was rendered, there was an agreement of what the value was. It was incorrect, as it turns out. That's a kind of an after-the-fact statement about an additional reason why Mr. Weckel didn't have to accept that check.
That wasn't the reason for returning the check?
No. The reason in the letter, as stated in 2004, was that the check was inconsistent with the 2004 settlement agreement, which allowed Mr. Weckel to sell his shares to the ESOP.
And that's what it actually said in the letter, correct?
Exactly, Judge. We did say at a later point in time, by the way, the check was in the wrong amount. By mutual agreement, it would have cost plaintiff $400,000. We didn't turn back the check and say it's the wrong amount. You breached the agreement. But again, it was a mutual error, allowing it set forth in the 2004 settlement agreement.
So, counsel, your opponent then hitches that reason for not accepting the check into the date of accrual, and saying, well, your selection of the date of accrual then reinforces that was the reason. So I don't need to have you jump around, but tell me where you get to your date, the date of accrual
Judge,
that you think is appropriate.
Well, do you mean accrual for when interest was due, or
Correct.
accrual? This is where the defendant has conflated two completely separate concepts. The date that we have used, the March 30, 2004 date, is the date that Mr. Weckel was terminated. We use that date because that's the exact same date that the defendant used to calculate interest when it initially issued that first check. We haven't picked a date, anything other than what the defendant did. And that date comes directly from the shareholder agreement that says the interest rate shall be determined as of the first date that Cole & Russell is obligated to pay interest under this agreement. That date was March 30th, 2004. The defendant set that date. If you look at it, it's attached to the letter I wrote Mr. Calico. That's the date they set. And now they're attacking us for using the exact same date that they used as the accrual date for payment of the date to set interest, not the accrual of the claim.
But if they had an obligation at that point, and when exactly are you saying that the claims for breach of contract arose? I mean, what exact date are you saying that your claims for breach of contract were right?
I'm saying the breach occurred on November 2nd, 2011, when Ms. Bond stated for the first time throughout this litigation that Cole & Russell was not going to pay Mr. Weckel pursuant to the shareholder agreement. Our view then is that because we proceeded to pursue the 2008 settlement agreement, we're not going to hold them responsible for the time it took to work through that issue. The claim then became ripe when all of those efforts were exhausted on March 15th, 2018. So the obligation to pay interest, that goes into the bucket, a separate bucket. That's contractual interest that's due under the shareholder agreement. That arose in March of 2004. Under the shareholder agreement, that's the date that you use to peg the interest rate that will apply for everything.
And you're saying that is separate from the prejudgment interest. You're saying that's the date for the contractual interest, but not the prejudgment interest.
Exactly, Judge. Prejudgment interest, from our perspective, as a matter of fairness, would run from March 15th, 2018, when the shareholder agreement became the vehicle, the alternative vehicle, the only vehicle at that time for Mr. Weckel to get his shares to get redeemed.
Okay.
I have another question.
Yes.
As I understand it, the shareholder agreement differentiates between cause and not cause with regard to determinations on the payments on the shares, right? And I understand that there's a letter that was produced back when, with regard to there was sort of I don't know what I call it, but sort of like an acknowledgement that there was no cause, I think it was, in that termination letter. There was some sort of acknowledgement on cause or something like that with that termination letter.
Judge, no, it doesn't. It basically says, and it's in the record, it says, we're terminating you because we've lost confidence in you. We recognize your contribution to the company over the past several years. We're offering you this if you resign. And if you resign, and if you accept this offer, we'll put together a severance package which will require a release of claims. If you don't accept this, you will be terminated. The letter doesn't say cause or no cause. And it's important that it doesn't say, if you don't accept this package, we will involuntarily terminate you without cause pursuant to the shareholder agreement. It doesn't say that at all. It doesn't say cause or no cause. The cause comes from the reference to lack of confidence, and then all the testimony at the trial about what the lack of confidence came from. And that's where Mr. Russell talked about misconduct, performance, all those things that amounted to cause under any definition. The shareholder agreement doesn't define what cause is, but just as a matter of common sense, if you're firing somebody because you've lost confidence in them, they've created issues.
And the testimony you're referring to is with regard to the wrongful termination action?
Yes, Your Honor.
Okay.
Yes, and that's where judicial estoppel comes into play, in my view. They went down that path at the trial to say that Mr. Weckel deserved to be terminated. There was cause for termination. They got the benefit of that through the jury verdict. The testimony was all under oath. And then, a year after they're faced with $1 million judgment, Colin Russell says, no, it wasn't for cause. It wasn't really for cause. And despite the fact that they admitted that it was effectively for cause twice. In the original answer to the complaint, they admitted that the jury's verdict was effectively for cause. In the amended complaint, we made the exact same allegation. They never responded to the amended complaint, which again is an admission. So they've twice admitted that Mr. Weckel was effectively terminated for cause. And now, again, only after they're hit with $1 million judgment, they want to say that that's not really what happened. The other point on that, too, Your Honors, is that whether it's for cause or without cause, ultimately amounts to a difference of about $4,000 in the grand scheme of things. It's not a huge amount. Any other questions on it?
Was there any evidence in the record that the termination was without cause?
In the trial court record, or, I'm sorry, the trial?
Well, in the case that we have before us, not anything that had occurred in any of the proceedings, but the case that we have before us that was resolved on summary judgment, what was before the trial court on summary judgment on evidence that the termination was without cause, that is, not for a cause, but without cause.
The only evidence is their argument.
And that's really the question for your opponent that I'm asking you.
The only evidence, Judge, is their argument that it was without cause based on the termination letter, which doesn't say one way or the other, but which I would say says that Mr. Weckel was terminated for cause, loss of confidence, but in light of his contributions, the company's trying to, quote, make it a soft landing. It's a soft landing if you sign a release and you don't sue us. So I don't think that that letter in any way indicates that this was without cause. And as I said before, it doesn't say if you don't accept this package, you'll be terminated involuntarily without cause under the shareholder agreement, which would be an important phrase to use in the termination letter, given that he had a shareholder agreement that played into this, whether it was termination for cause or without cause. On the interest rate, I think we touched on this before. Colin Russell wants to change the interest rate depending on different events, but as I said, the applicable interest rate was set forth in the shareholder agreement. It was determined as of May 30th, 2004 by Colin Russell That's the date that you use to determine the interest rate. That interest rate then applies for all purposes under the Ohio Revised Code. It applies for contractual interest, it applies to prejudgment interest, and it applies to post-judgment interest. It's the same rate going forward for all purposes. Unless there are any further questions, I believe I'm finished.
Okay, thank you.
Thank you.
You have about 3.5 minutes remaining.
Thank you, Your Honor. Let me address your question about, is there evidence in the record showing it was not for cause? There
Yeah,
absolutely is
because it was
evidence.
disposed on summary judgment.
There absolutely is evidence in the record. There was an affidavit from the CEO of Cole & Russell that was part of the record, specifically stating that Cole & Russell made the determination to terminate him without cause, which is supported by the termination letter, which is also in the record. There was an allegation.
So the same termination letter that's been discussed.
Yes.
So there's two different readings on that termination letter.
Yes, but the affidavit, this sworn affidavit is also part of the record, explaining that the decision was made and explaining why the termination letter was worded the way it was because of the decision to make it a termination not for cause pursuant to the shareholder agreement.
But the argument at trial was that it was for cause.
The argument at trial was from the plaintiff that we lacked a legitimate business justification, which is the legal standard for a minority shareholder. We explained that, no, there was a legitimate business explanation underlying our determination that we would terminate him, but there was never a statement that we terminated him for cause under the shareholder agreement. This claim
And this
that
is again with the wrongful termination.
Yes.
Because as I understand it, okay, so the affidavit that you're referring to.
The affidavit is in this
Correct.
case.
But the affidavit goes all the way back when we didn't have gray hair. So, right, I forget the 2004, I think 2005, whatever it was. Okay. So that affidavit, which would have been created at the time that the termination was looming, right? And things were being negotiated possibly or whatever. It's that affidavit that you're relying on.
No, this is a new affidavit that was entered specifically as part of this new litigation.
Okay, so it was part of with regard to the summary judgment itself.
Yes.
Okay.
Yes.
Got
And
it.
to the allegation that Cole & Russell has admitted in response to an allegation in the complaint that we terminated Mr. Weckel for cause, no, I would urge you to review our briefing and the recitations that we admitted in the complaint says that the jury found that there was a cause for his termination. That's correct. The jury did find that we had a legitimate reason to make the decision to terminate him. The jury did not find, because they never addressed whether we terminated him under the shareholder agreement for cause. A couple other points I just want to point out very quickly.
You have about 30 seconds left.
In page 28 of their brief, they absolutely make the argument that Mr. Weckel could not accept that check that was sent by Cole & Russell because it was for the incorrect amount under the shareholder agreement.
At the time, the representation from Mr. Weckel was that he was not accepting it because it was, I can't remember the exact word, it was contrary to or doesn't align with the settlement agreement.
That's correct. But for purposes of determining whether he had a right claim, the fact that it was the wrong amount, which whether he thought about it at the time or he just looked back, it absolutely was the wrong amount at that time.
So
under his
it doesn't
agreement.
matter if he didn't realize it at the time?
Correct. He
But
still
would
had a
have it
valid
really
right claim
mattered
for
if it
breach
was
of
the
contract.
wrong amount, if there was a settlement agreement, that settlement agreement was perceived to have been breached, and that was the basis of the cause of action? In other words, the settlement agreement would have set aside the shareholder agreement.
And that's why we see that res judicata applies, because, as Mr. Weckel acknowledges, a positive outcome on his claim would have mooted the relief under the shareholder agreement. They're so interconnected that one goes with the other. It's the same relief sought. That's why you have to bring all those claims in the same cause of action. For equitable considerations, there is a equitable claim that was brought in this new case. It was not addressed by the court on summary judgment. If the court feels inclined, and we think the equities really go both ways. There can be a remand to the court if he wants to argue that from an equity perspective, he should get his $153,000 back because that's what he paid for the shares. That could be a claim that goes back to this court, but that does not overcome res judicata, and that his claim for over $1 million for redemption of his shares under the shareholder agreement is not valid.
Okay, your time has expired.
Thank you very much.
Okay, thank you. This case has now been submitted. We will take a short recess.
The Honorable Marilyn Zayas is back in session. Please be seated.
Good morning. I hope everyone had a great weekend. All right, so we are here now on the case of State v. Collins, which is case number 24001. And I know that attorneys have already identified themselves. I presume that you're ready to proceed. Okay. And it's Attorney Leap, right? Okay. Just come forward when you're ready.
Good morning. May it
Good
please the
morning.
court. As I said, Stephanie Leap on behalf of the appellant, Ms. Regina Collins.
And how much time would you like to reserve?
2 minutes, please.
All right, no worries.
Are you ready for me to go?
We're ready for you.
So Ms. Collins is requesting reversal on her 4 assignments of error. I'm going to start with the sufficiency and weight of the evidence and talk about those together. There's kind of 2 sub-issues here. There's the amount of the theft and the issue of consent, which are 2 essential elements of this offense. As to the amount, the numbers don't really line up. It's not really clear what the amount of the alleged theft is here. The trial court finds that the amount is $15,000 and change, the amount that's due to these 2 nursing homes. However, that's more than she actually received of her father's funds in any of these bank accounts during the period of time that he was in those nursing homes.
And is that the only time, based on the trial court's finding, when we're examining sufficiency, we're only looking at the time that he's in the nursing home?
That's my interpretation
Okay.
of the trial court's decision, because the trial court's saying, okay, what she's stealing is what she owed to these nursing homes. It's honestly very confusing altogether, exactly what she's alleged to have done here. But my interpretation is we're talking about the time that he's in these 2 nursing homes. And prior to him being in the nursing homes, he was out and about spending the money himself as well. So it's hard to say how can Ms. Collins have been stealing money if they're both using the money in these accounts.
And was the evidence clear that that there was never any money just sitting in the accounts and she was immediately taking them out? Because I understand your argument that there were no Social Security payments while her father was in the nursing home. But was there money from a prior payment in the account that she used while he was in the nursing home?
It appears from that exhibit, I think that's the U.S. bank record, which is Exhibit 6, that account where the Social Security was going was closed February of 2018.
Oh, so, okay. So she couldn't have used any of that money for her own benefit while he was not living with her?
Correct.
Okay.
And why was he not getting Social Security anymore? Was that going straight to the facilities?
The record is not entirely clear, but there is some discussion in the record from Ms. Opperman and the witness from Premier, the second nursing home in Batavia, that there was some mix-up with the first nursing home, that the payments stopped coming. So they were supposed to, I believe, go to the nursing homes directly, but some
Right, because if he's
happened.
on like Medicaid, that's how I would imagine that it would happen.
Correct. Some mix-up happened in that first nursing home. It's not entirely clear what happened, but Ms. Opperman did point out that, yes, the checks stopped coming in at some point. And we see in the record that, in the bank records, that it stopped coming in February of 2018 to that U.S. bank account, and then that account was closed that same month.
So is your argument focusing solely on the other source of income that was coming in? That was the retirement money?
So the retirement money is the most that she ever received during this time period is $12,000. So she's being held responsible for more than she even could have possibly stolen. I'm not conceding that she stole the money. It's my argument that that evidence is insufficient that she committed the theft. However, if we're just talking about the amount of the theft, the evidence is extremely unclear as to what she stole. They're saying she stole $15,000, which is the amount owed to the nursing homes. However, she only ever received $12,000 during that period of time of these funds.
Received, or direct me to the evidence of access. I mean, was there more money that she had access to in the account that she also could have stolen?
If you look at those records, that's the Chase Bank records in Exhibit 5. So those records actually go back prior to when he was in the nursing home, and they go up through November of 2019. This bank account, there wasn't money sitting in any of these bank accounts.
She took it out immediately.
Some money is coming out immediately, but bills are getting paid. All sorts of things are going through these accounts. Bills are getting paid. Groceries are being bought. Money spent at Lowe's. The normal stuff that you expect people to spend money on. But the money there's no money sitting in the account. The money comes in, it gets down to almost nothing. There's no money sitting in there.
But help me out. If the range for this caliber felony is $7,500 to $37,000, like let's say the trial court erred in coming up with $15,000, but there was potentially $12,000, like, is that harmless at the end of the day?
It does still put us in the same level of offense, but my argument is that it's not clear what was actually, if she stole money, the amount of the offense there's not sufficient evidence to say what the amount was here. What I'm pointing out with the numbers is that the numbers don't even line up. She's being alleged to have stolen more than she actually could have potentially stolen. Now the trial court is saying, well, I believe that Ms. Collins at least had some consent to use this money from her father, but what is that? So how do we decide what is the
Well, but if the trial court said, and I don't think it did say, but if the trial court said, like, I can't really tell how much, but at least $7,500, then that wouldn't be an issue, would it?
It wouldn't, but he doesn't say that. Right. He just says, I believe she had some consent.
But wasn't that really for when they were living together? I mean, at the time that he goes into long-term care, what could she possibly be spending? How could she be spending the money on him, right?
Was she still maintaining their home? It was his home. She's still paying bills and maintaining the home and upkeeping that property during the time that he's there. So now I'm not sure if this isn't in the record, if she's buying things and taking them to the nursing home. I mean, I know people do that, but that's really outside of the record. Mm-hmm. As far as the consent goes, I'll move on from I'm going to say one more thing as far as the amount of the offense. We don't have any detailed invoices about what these charges are for. There were disputes as to the amounts. There was a dispute with Premier at one point, the Batavia nursing home, where they wanted to kick him out because of financial issues, and they ruled in Ms. Collins' favor. That's also in the record. So moving on to the consent here, the trial court said himself, the crux here is Mr. Collins expressed or implied consent. And then the trial court also says, we don't have a lot of evidence about that, and that's accurate. The evidence is insufficient here. The only evidence in the record as far as Mr. Collins' consent as to what she can use the money for is the power of attorney, which expressly says no limitations. None of the state's witnesses can talk about Mr. Collins' consent.
But no limitations doesn't mean that she can just gift herself the money.
It does expressly say in the power of attorney that it allows the agent to use the funds to their own benefit so long as it's a relative. Then it also separately in another part of it says there's no limitations.
So your argument is that the no limitations means that she can just gift herself however much money she wants?
That plus the other portion of the power of attorney that says you can't gift yourself money essentially unless you're a relative. And there's a list of relatives. And
Well, but
she
there
is-
also has to be, like, I dealt with this with my dad in this situation, but like, you also have to provide for his living expenses. So like, you couldn't, regardless of what the contract says, I don't think you could just give yourself money while leaving him high and dry with his responsibilities.
So the other evidence that we have is the brother. So the only person that's in the record that stood to benefit from, as an heir to any money that Mr. Collins may have had. Obviously, we're not talking about a lot of money here and probably would have gotten eaten up in debt going through probate. However, the one person that testified at trial that would have had any benefit, he comes in and he talks about the history of these two living together. Ms. Collins and her father living together and putting their money together and paying bills together. This is a history of, this is how they manage their money together. Everything goes into together and they pay the bills out of that. And he even says, I absolutely think that she acted within my father's consent.
Was he referring to during the time that he was in the long-term care facility?
I don't believe his testimony
Was that
indicates any
specific?
specific date.
Because I think that's what the trial court did here. I mean, he looked at the fact that the two of them were living together, and it was very difficult for him to figure out what was for her father's benefit. But then when he moved out and was in a long-term care facility, and she wasn't paying those bills, he thought, okay, that's when she was using the money for her own benefit, not for the benefit of her father.
It almost sounds like your argument is that the state didn't meet their burden and that the only evidence that there was lack of consent, that there wasn't any evidence of lack of consent.
Yes, it's
That
my
there was
argument.
evidence of consent, but there wasn't evidence of lack of consent.
Yes. It's my argument that the state did not, that there's insufficient evidence presented by the state to prove the consent issue or the amount of the offense, which are the two essential elements here. I'm just going to talk about the case law a little bit that's in some of the briefs. This is kind of an odd case, and there's not a lot of precedent on this exact type of case. I did find a few cases, and the state also talked about one of these cases. The few cases that I saw was Haggerty, Hanusowski, and Pfeiffer. And those cases, there was something more to show the lack of consent, that the theft was beyond the scope of consent. And Haggerty, the victim, was still alive and able to testify that that was not within my consent. What that person did with my property was outside of my consent. In Hanusowski, we have a power of attorney who is actually a non-relative and is going way beyond the scope of the power of attorney. The power of attorney in that case is specific that there's two agents and you both have to sign off on transactions. And then we have family members coming in and saying that was not what my parent or my relative intended. Whereas here we have the only family member. Oh, I'm sorry.
Give her a minute.
And then in Pfeiffer, there was also a victim that testified. Even in that case, the court found insufficient evidence because the defendant at the time reasonably believed they were entitled to use the funds, and that's very similar to our situation. Thank you.
Thank you.
Good morning, Your Honors. May it please the court.
morning.
To answer some of the panel's questions, Judge Krause said the question about what time period is controlling here. I think the evidence was the state presented evidence that there were these gratuitous transfers to herself and expenditures that were improper, at the very least dating back to 2016 when the power of attorney was executed. And even if it wasn't during the time of his long-term care, the evidence was that she didn't put anything away for a rainy day to try to save money for when he might need it or when his other expenses might come due.
But how do we know before the time period where he wasn't living with her that she wasn't spending money on him? Because I'm looking at Exhibit 7, and all I see is just a bunch of ATM and cashback and Walmart cashback.
Yeah.
I mean, it's just a bunch of getting cash out. but they were living together at the time, so how do we know at that point?
That's a fair question, Your Honor, but I think that given the fact that the amounts that were appropriated during the time of his long-term care would ultimately amount to a third-degree felony anyway. I think that's not key.
But like, don't we, I mean, part of my trouble with this case is the trial court seems to acknowledge the imprecision in all of this. And like, if the trial court had made a finding, as I mentioned to opposing counsel, like, it's confusing, it's not totally clear, but at least 7,500.
Yeah.
That makes me more comfortable. But like, the amount here, just like, how do we know what the amount is and how does it tie to the evidence?
Well, I guess part of the blanks are filled in during the restitution hearing, where there's indicated that she was receiving this money and not paying the nursing homes. But I think the indication is, and the evidence indicated, that of all the money that she received during the time that he was in long-term care, none of it went to his care. So it was at least the amount that was owed to the nursing homes that would
wait a second,
constitute the offense.
What about the argument that only $12,000 came into the account? Because we have no Social Security money that's coming into the account at the time that he was in long-term care. So we're looking at the retirement money.
Right.
And the argument is that only $12,000 came into the account at that time. So how could she have misappropriated more than $12,000?
Well, I mean, that's the kind of $64 question. I can't answer that much, but my point is that at least $12,000 was accounted for by the evidence in the record, because that was the amount that she was obligated to pay on his behalf for the nursing care that didn't happen.
At least $12,000, but she was ordered to pay more than that in restitution.
I understand, Your Honor.
Is there a problem with that?
I think that there could be a problem with the restitution order, but I think the underlying conviction would still stand under these circumstances.
Because it was at least $7,500.
Correct.
Well, I guess, I'm confused about the disputes that she had with the nursing home and whether that affects the ultimate amount due. And this bleeds into the restitution point, because like, this was money that she allegedly took from him, not from the nursing homes. And the nursing homes they know how to get their money. And like, I don't see any evidence that they got a judgment against her father or anything like that. And like, if they wrote the debt off, like, I don't know whether they did or they didn't, but like, how do we think about this?
Well, again, I think that's something that would have to be explored in connection to the restitution order. There's nothing in the record to indicate that they wrote any of this debt off, or that there were any civil actions that were just threatened or instituted during the time of the indictment. So it's
how are they victims?
Well, Your Honor, I think that they had a right to this money under the three factors that are set forth in Allen. As you know, it's expanded the extent to which someone can be considered a victim under the restitution statute. They had an interest in this money, and that was owed to them. They bore the economic loss of this crime because they didn't get the money that was owed to them. And the entity was a target here within the meaning of Allen, because she dealt directly with the nursing homes and withheld money from them. It wasn't there was no intermediary there.
So in the future, any kind of case like this where the person doesn't pay the bills, the business that is owed the money can say that they're the victim?
Well, I think under the circumstances of this case, yes, Judge, because I think the key to this is that the third Allen factor is to be considered is that she dealt directly with the victim of the crime here. She knew that they were owed money. She withheld the money knowing that it was.
Well, so would that be different, going to Judge Krause's point, would that be different if it was Spectrum or Verizon or like 75 other bills that you might get on a monthly basis?
Yeah, I think it could be, yeah. And I think that that's a distinction they've made with respect to credit card debt. So.
That credit card companies are not victims?
Correct, yes. But I think in this case that they're.
So how do we draw the line?
Well, I think the direct contact is something that's mentioned in Allen, and I think that's what we have here. She dealt directly with these nursing homes.
So if she was arguing with Spectrum about a bill and she had direct contact with Spectrum, they would then become a victim?
I don't know. Off the top of my head, I don't know. But I know under the Allen factors, I would just indicate that there's at least some. And another thing to consider here is that we're operating under a plain error standard. There was no objection to any of the restitution amount or to to where it was going to go. So I think that that there's valid questions, but I don't think it's something that should be recognized as plain error in this case. In terms of the consent, I think the Handy-Sosky case is probably the closest one we have here. Indicates that gratuitous transfers are not permissible absent an express declaration in the power of attorney that they can do it. Here, it's evidence was, and this evidence came from Ms. Collins herself, is that she spent money at the casino. This is at page 26 of Ms. Kurtz's testimony. Is that it was her understanding, based on her interaction with the defendant, that Ms. Collins was spending this money at casinos. And I think
are we looking at the time period? Because she said she went with her father. So are we looking at the time period that her father was incapacitated in a nursing home for the casino?
Well, this would have been a time when she was in contact with Ms. Kurtz. It would have time, at least the time frame was when he was in long-term care.
Right.
I mean, it's not completely clear from the testimony what time frame she was indicating, but it arose in the context of why wasn't Ms. Collins paying for this? And Ms. Kurtz said, based on her interaction with the defendant, it was because she was spending the money at casinos. And I would take that to mean during the time that he was in long-term care, because that was really the issue.
She's saying that the defendant admitted that she spent the money on casinos?
Yeah, that's at page 26 of the transcript. And there's some question of, I think Ms. Lathe indicates that was based on the affidavit of her sister, but my reading of that testimony is that it's not. It's based on Mrs. Kurtz's own interaction with the defendant.
Okay.
And if I'm wrong,
but I'm only seeing like 2 dates that have the Miami Valley Gaming during the time her father was in the long-term care.
Yeah, right.
For a few $100s.
Right.
And then what about the rest of all this cash money? I mean, is the insinuation that she was also using that to gamble?
Well, right. If she's not spending any money on her father's care, whether it was gambling or not,
it's on herself.
Well, I guess I just want to push back on that. And again, it's from my own personal experience, but like, there's a lot of things that the nursing homes provide, but there's also a lot of things they don't provide depending on the circumstance. And so, like, I was forever ferrying stuff over to my dad and getting stuff that would be beneficial to him. Right. And I think like what's unclear here is like it was cash withdrawals. So like we don't know, but I mean, that's certainly possible that, it's certainly possible that she was bringing him stuff that he needed.
I guess what the point is that the trial court heard all the evidence, and that's an inference that could be made, is that she was spending money on her father, but that's not the only inference that can be made, and I don't think it renders this conviction contrary to the weight or manifest weight of the evidence or the sufficiency of the evidence. To answer your question, Judge Bergeron, Batavia at some point became the payee of the Social Security money. That's at transcript page 73.
And right, so then my question is like, did they account for whatever funds they received from Social Security in like the amount that they're saying that they're owed?
My understanding is that it was accounted. That was the only thing that the two nursing home representatives testified to was the amount that had not been paid. There's no indication that they failed to take into consideration any third party.
Attorney Sauter, I want to make sure I understand your position on a couple of things. So with regard to the language of the power of attorney that is being relied upon, I think your position is that that's not sufficient because there has to be an express, it must be expressly allowed.
Yes, Your Honor.
Okay. Now, with regard to whether the amount, because the amount determines the level of the offense, the state would have had the burden on establishing the amount. Is that correct?
Well, it would have the burden of establishing a theft in at least an amount of $7,500,
okay.
Correct.
And it seems as if even that it seems to be nebulous, whether it was $7,500, right?
Well, our position is that she should have paid the nursing homes and that the evidence that they adduced was sufficient to indicate that it was at least $7,500. It was roughly at least $12,000.
So when you say she should have paid the nursing homes, is that under a contractual obligation or under just general obligations of having power of attorney?
Well, yeah, I would say probably both, but at least the power of attorney. She was acting in his stead. He was obligated to pay it, and she, instead of spending the money on what she should have, she's spending on other things. So my argument would be that both the lack of consent, the fact of a theft, and the amount were determined within accordance with what the trial court found.
Okay. And if we were to find that there was a theft, but the amount is not established and we cannot say that it amounts to $7,500, would the charge be dismissed or would it be amended to a misdemeanor?
If there were a finding of theft in some amount, it would at least be the lesser included offense of an M1. This was charged as a felony 3, so that there would also be a possibility of a lesser included as an F4. But my argument would be that the
depending on what it was that the state has,
exactly.
What it is that is determined that the state has established.
But if the court determines that there has been a theft, though, there has been a crime, it's at the very least a misdemeanor of the first degree.
Okay. Thank you.
Unless the panel has questions, I will rest on my brief. Thank you very much.
All right, thank you.
I still have time left.
You have 2 minutes.
Thank you. I didn't really get to the topic of restitution, but I think that the issue of whether or not these nursing homes are victims also ties into the sufficiency and weight of the evidence argument. A lot of the trial court's reasoning is based on what's owed to the nursing homes and why that the nursing homes didn't get paid. If looking at whether or not they should be the ones to receive restitution, I understand this is a hybrid and it wasn't addressed at the trial court, so we're dealing with plain error. Under Allen, and then there's also Jones, the state cited. In Allen, we have a bank who had the obligation to repay checks that were presented fraudulently. So the bank was the actual target of the offense. Allen makes distinguishes between a bank, who is the target of a fraudulent check scheme, and an insurance company who has to pay out. And when we're talking about nursing homes, unpaid medical bills, unpaid other bills, that is more akin to the insurance company. In Jones, you have a situation where a person used a stolen credit card to purchase something, the goods were provided, and then the person who owned the credit card disputed it. So this business owner provided stuff with a fraudulent payment, and they were out the money. So that person was permitted to be the victim. Where we're talking here about creditors who are not getting paid, where Mr. Collins, whether or not Ms. Collins used the money appropriately, he only had a small amount of money coming in, and he did have other needs outside of paying these nursing home bills. He still had a home that he owned at the time. There were utility bills. Like the judge said, there are things that he may need. I'm not thoroughly versed in that, it's not in the record, but there are going to be things that someone needs while they're in a nursing home outside of what is provided. I think I'm probably running out of time, so unless there are any
I'll let you
questions.
finish your thought. I mean, whatever, go ahead and finish whatever.
I think I'm,
Yeah. Okay.
I have
You
some
got
other
there.
points, but I don't think I have time for
All right.
So,
Right.
thank you.
Thank you both for your arguments this morning. We'll take the matter under submission, issue a timely decision, and we wish you both a wonderful afternoon and a great week. Renata, just give me 1 little second. And that concludes the proceedings for today. Thank you.
Court of Appeals, first